For years, millions of people living in the United States have been trapped in a state of suspended animation. They wake up every morning, go to work, pay their taxes, and contribute to their communities, all while holding a temporary status that could vanish with the stroke of a pen. They check a website once a month, hitting the refresh button with trembling hands, hoping to see a specific date change. For the vast majority, that date never moves. It remains frozen in time, a bureaucratic wall separating them from their future. But sometimes, the gears of Washington grind in an unexpected direction. Sometimes, the dam breaks. We are currently looking at a document that has just been released. A document that usually brings disappointment, but this time, it has brought a shockwave. For a specific group of people, thousands of them, the waiting game is abruptly, violently over. The door is not just cracked open, it has been kicked wide. But here is the catch. This window of opportunity is terrifyingly small. It is a flash in the pan, and if you do not understand what is happening in the next few weeks, you might miss the single greatest chance you will ever have to secure your permanent freedom in this country. Hello and welcome to U.S. Policy Brief. I am your host, Michael. Today, we are setting aside the rhetoric and the political posturing to look at the raw mechanics of the American immigration system. Specifically, we are breaking down the April 2026 Visa Bulletin. To the uninitiated, a Visa Bulletin sounds like a dry government memo. But to those in the trenches of the immigration system, it is the most important document in the world. It is the scorecard that determines who gets to stay and who has to leave. And the numbers we are seeing for April 2026 are nothing short of historic. We are seeing movement in categories that have been stagnant for years. We are seeing a current status, the holy grail of immigration, appear for employment categories that were previously backlogged. We are seeing a massive opening for families. But why is this happening now? Why, in the middle of a complex political year, has the Department of State decided to open the floodgates? And most importantly, how do you ensure you are on the right side of this wave? Over the next 20 minutes, we are going to dissect every line of this bulletin, explain the visa pause phenomenon, and give you the tactical roadmap you need to navigate this sudden shift. To truly appreciate the magnitude of the April 2026 bulletin, we first have to step back and understand the architecture of the trap that so many people are in. The United States immigration system, largely defined by the Immigration Act of 1990, operates on a rigid quota system. There is a cap on how many green cards can be issued annually, 140,000 for employment-based immigrants, and a complicated formula for family-based immigrants that usually hovers around 226,000. But the real bottleneck is not just the total number, it is the per-country cap. No single country can account for more than 7% of the total green cards in a category. This creates a nightmare scenario for applicants from high-population countries like India, China, Mexico, and the Philippines. If you are a software engineer from Iceland, you might get your green card in a year. If you are a software engineer from India with the exact same credentials, you might wait 15 years or more. This is the backlog. It is a line that moves at different speeds depending on where you were born. The Visa Bulletin is the monthly update that tells us where the front of that line is. It has two charts, final action dates, which tells you when a visa can actually be issued, and dates for filing, which tells you when you are allowed to submit your application to get in line for the final stage. Usually these dates move by days or weeks. Sometimes they even move backward, a phenomenon called retrogression, which is devastating. But April 2026 is different. We are seeing jumps of months, and in some cases, years. We are seeing entire categories become current, meaning there is no wait time at all for filing. This suggests a surplus of visa numbers that the government needs to use up before the fiscal year ends. Let's dive into the specifics, starting with the economic engine of the immigration system, the employment-based EB categories. The most shocking development is in the EB2 category. This category is for professionals holding advanced degrees, master's degrees and above, or persons of exceptional ability. For a long time, this category has been clogged. But in April 2026, For the rest of world category, that means everyone except India and China, the EB2 status is going to be current. This is a massive development. It means that if you are a researcher from Brazil, a doctor from Nigeria, or an architect from France, and you have an approved labor certification and I-140 petition, you can file for your green card adjustment of status immediately. There is no line. You are at the front. Let's illustrate this with a scenario. Imagine a character named Dr. Aris. Dr. Aris is a brilliant biochemist from Greece, working in a lab in Boston on a temporary H-1B visa. He has been in the US for 4 years. His employer filed his paperwork 2 years ago, but he has been stuck waiting because the priority dates were backlogged. He cannot change jobs easily, he cannot start his own company, and he lives in fear that if he loses his job, he has 60 days to leave the country. When the April 2026 bulletin drops, Dr. Aris sees "current" next to his category. Suddenly, the handcuffs are off. He can file his Form Y-485. Once he files that form, he gets pending status. He can apply for a work permit that allows him to work anywhere. He can apply for advance parole to travel home to see his parents without begging for a visa stamp at an embassy. This current designation is effectively his liberation. However, the story is more complex for our friends from India and China. While they did not become current, there is significant movement. EB2 India has advanced by 10 months to July 15, 2014. Now, to an outsider, seeing a date from 2014 in the year 2026 sounds absurd. It means they are processing applications filed 12 years ago. But in the world of the Indian backlog, a 10-month jump in a single bulletin is a sprint. It indicates that the government is trying to clear out the oldest inventory. For thousands of Indian nationals who have been waiting for over a decade, this movement brings them agonizingly closer to the finish line. It is a sign of life in a system that often feels dead. The biggest news, however, might be in the EB3 category. EB3 covers skilled workers, professionals, and other workers. This is the backbone of the workforce. For April 2026, EB3 worldwide, excluding India and China, is advancing by 8 months to June 1, 2024. That is a massive leap. It brings the date very close to being current. And looking at the dates for filing chart, EB3 worldwide is actually going to be current. This distinction is crucial. Even if your priority date isn't ready for the final green card issuance, final action, the fact that dates for filing is current means you can submit your application package now. You can get your foot in the door. You can get the benefits of being a pending adjustment applicant. This is a strategic opening that allows employers to retain talent that was at risk of timing out. But why is this happening? Why is there suddenly a surplus? The answer lies in the concept of visa spillover and the current geopolitical situation regarding consular processing. The immigration attorney sources we are analyzing suggest that there is a visa pause affecting consular processing in many countries. This could be due to staffing shortages, diplomatic tensions, or administrative backlogs at embassies abroad. When the Department of State cannot issue enough visas to people waiting outside the United States, consular processing, those unused visa numbers do not just disappear. By law, they often spill over to the applicants who are already inside the United States applying for adjustment of status. Think of it like a theater. If the people waiting in the line outside cannot get through the security check fast enough, the manager might decide to fill the empty seats with people who are already in the lobby. That is what is happening here. Because embassies in places like Manila, Ciudad Juarez, or Mumbai might be processing slower than expected for certain categories, the system is reallocating those numbers to people who are already here on H-1B, L-1, or student visas. This creates a unique advantage for those physically present in the US. It is a perverse incentive in a way, but it is the reality of the 2026 landscape. If you are here, you have a massive advantage over someone with the exact same credentials who is waiting abroad. Now, let's pivot to the family-based categories, because this is where the emotional stakes are often the highest. We are talking about the separation of husbands and wives, parents and children. The F2A category is the one to watch. This category covers spouses and unmarried children, under 21, of green card holders, lawful permanent residents. For a long time, this category was current, meaning if you married a green card holder, you could apply immediately. Then, a few years ago, it retrogressed badly, creating a wait time of several years. This was a tragedy for newlyweds who found themselves living apart or struggling to maintain status. For April 2026, the dates for filing for F2A is becoming current for all countries. This is momentous. It means that if you are a foreign national student on an F1 visa or a worker on an H1B and you marry a green card holder, you can file your adjustment of status application in April. You do not have to wait for your spouse to become a U.S. citizen. You do not have to worry about your student visa expiring next month. You can file the I-485, Form I-130, and the work permit application concurrently. Let's imagine a couple, Liam and Maria. Liam is a green card holder from Ireland. Maria is from Colombia, finishing her master's degree in the U.S. on a student visa. Her visa expires in May. They are married, but under the old Bulletin, Maria couldn't file for her green card because the dates were backlogged. She was facing the terrifying prospect of having to leave the U.S. and return to Colombia, potentially being separated from Liam for 2 or 3 years while the paperwork processed. With the April 2026 Bulletin making dates for filing current, Maria is saved. She can file in April. As long as the application is pending, she can stay in the U.S. legally, even after her student visa expires. She can get a work permit. She can start her life with Liam. This bulletin literally saves their marriage from the strain of international separation. We also see significant movement in the F1 category, unmarried sons and daughters of U.S. citizens, which advanced nearly 6 months for the worldwide category. The F3, married sons and daughters, and F4, brothers and sisters, categories also saw movement of 3 to 5 months, while F4 still has a wait time of nearly 20 years for some countries, a testament to the broken nature of the system. Any movement forward is better than stagnation. For the Philippines specifically, the F4 category jumped 5 months. That is 5 months of backlog cleared in a single bulletin. However, we must temper this excitement with a heavy dose of caution. In the world of immigration, good news is often temporary. This phenomenon is known as the fiscal year surge. We are in the middle of the fiscal year. The government is releasing numbers now to ensure they use the quota, but if demand is higher than they anticipate, if Dr. Aris, Maria, and hundreds of thousands of others all file in April, the government might realize by June or July that they are running out of numbers. When that happens, the dates will retrogress. They will move backward. The door that was kicked wide open in April might slam shut in July. This creates a tremendous urgency. If you are eligible to file in April 2026, you cannot wait. You cannot say, "I'll get my paperwork together next month." You need to file the moment the window opens. You need to have your medical examination, Form I-693, sealed and ready. You need your birth certificates translated. You need your tax returns organized. Immigration attorneys are already warning that their offices will be flooded. If you miss this boat, you might be stranded on the pier for another 2 years. Let's talk about the practical steps of what adjustment of status actually entails, because the bulletin is just the invitation. The application is the test. When you file based on this bulletin, you are subjecting yourself to a full background check. The government will look at every entry and exit you have made to the U.S. They will look at whether you ever worked without authorization. For employment-based applicants under Section 245K of the immigration law, a certain amount of status violation, up to 180 days, can be forgiven. But for family-based applicants married to green card holders, there is almost zero tolerance for status violations. You must be in lawful status at the moment you file. This is a critical distinction that trips people up. If Maria, our student from the earlier example, had let her student visa expire before April and fell out of status, she might not be able to use the F2A chart to adjust status inside the U.S. She would have to leave and process at the consulate, triggering potential bans. Because the chart is current now, she must ensure she is legal on the day the packet lands on the USCIS desk. This is why the dates for filing chart is so powerful. It protects people before they fall out of status. Another hidden subplot in this bulletin is the EB-5 category, the investor visa. It remains current for almost everyone and has seen movement for China. This path, which requires investing $800,000 or more in a U.S. business, remains the fast lane for the wealthy. But the fact that the government is prioritizing processing here shows their desperation for foreign capital injection into the economy. It is a stark reminder of the tiered nature of the system. Money buys speed, while labor buys a place in the line. We also need to address the pause mentioned in the breaking news reports. The concept of an embassy pause suggests that the State Department is overwhelmed. By shifting the burden to USCIS, the domestic agency, via adjustment of status, the government is effectively outsourcing the work to a different department that might have more capacity. It is a shell game of bureaucracy, but for the applicant, it doesn't matter why the window is open. It only matters that it is. So, what is the forecast for the rest of 2026? Based on this aggressive movement in April, analysts predict that May and June will continue to see forward momentum, particularly for the employment categories. The goal is to use every single visa available. The Department of State hates wasting visas. UN-issued visas are lost forever at the end of the year. They would rather advance the dates too far and then pull them back later than not advance them enough and leave visas on the table. This means we are entering a season of aggressive advancement. However, this also means we are entering a season of processing paralysis. As thousands of applications flood into USCIS service centers in April and May, the actual processing times for the green cards, the time it takes to get the physical card, will skyrocket. We might see the dates become current, but the processing time for the I-485 application might jump from 10 months to 20 months. You will get your foot in the door, but you will be standing in the lobby for a long time. But again, standing in the lobby with a work permit is infinitely better than standing outside in the rain.